Hello, this is a 200 jury charge for the RPR simulator. It will be 5 minutes long. Ready? The plaintiff, Anna B. Mandrake, brought an action in the Common Pleas Court of this county against the defendant, William H. Mandrake, in which she filed for a divorce from the defendant upon the ground of extreme cruelty. The defendant filed an answer in which he admitted the marriage of the plaintiff and the defendant at the time set forth in the petition, and that one child had been born of the marriage, and denied each and every other allegation in the plaintiff's petition contained. For a further defense, the defendant alleged that in an action brought in the Court of Common Pleas of Montgomery County in the Commonwealth of Pennsylvania, the plaintiff therein, William H. Mandrake, filed for a divorce from the said Anna B. Mandrake, and that on the 6th day of November 2015, the Court of Common Pleas of Montgomery, Pennsylvania rendered its judgment and its decree granting to the plaintiff therein, William H. Mandrake, a divorce for the aggressions of the respondent therein, Anna B. Mandrake. It was further pleaded that such Court of Common Pleas was a court of general jurisdiction and that the judgment of divorce granted therein was in full effect. The answer was the only answer received. Upon the trial of the case in the Common Pleas Court of this county, the plaintiff was called as a witness and testified on her own behalf, and at the conclusion of her evidence, the plaintiff rested. Thereupon, the defendant made a motion to dismiss the petition on the ground that the plaintiff had furnished no corroboration of her testimony, such motion being based upon the statutory provision that a divorce shall not be granted upon uncorroborated testimony of a party to the action. The motion being overruled, the defendant introduced in evidence a complete transcript of the record and papers in the proceedings had in the Court of Common Pleas of Montgomery County, Pennsylvania, in the case referred to in his answer. This transcript of the record of that case was duly authenticated according to the law. The defendant then renewed his motion to dismiss the petition on several grounds, the principal ones among them being that the evidence showed that the plaintiff had not been a resident of the state of Ohio for a year immediately preceding the commencement of the action, and that her testimony had not been corroborated. Thereupon, the court overruled the motion of the defendant and proceeding to grant to the plaintiff a decree of divorce upon the ground of extreme cruelty as charged in her petition. Motion for a new trial was eventually filed and overruled by the court, to which action of the court defendant accepted. The proceeding in this court is for the purpose of reversing the judgment of the Common Pleas Court. The first question presenting itself is as to whether or not this court has jurisdiction to review the judgment of the Common Pleas Court on error. It is claimed that the decision in Parrish versus Parrish is authority against the jurisdiction of this court to make such a review of the case. The case of Parrish versus Parrish determined that a decree of divorce, although obtained by fraud and false testimony, could not be set aside on an original bill filed at a subsequent term. This decision was based upon the proposition that sound public policy requires that a judgment or a decree, which affects directly the status of married persons by sundering the matrimonial tie and thereby enabling them to contract new matrimonial relations with other and innocent persons, should never be reopened. It was said in the course of the opinion that such a course would endanger the peace and good order of society and the happiness and well-being of those who innocently relied upon the stability of a decree of a court of competent jurisdiction, have formed a connection with the person who wrongfully perhaps secured its promulgation. At the time of this decision, there was a statute which provided that no appeal shall be obtained from the decree, but the same shall be final and conclusive. This statutory provision was said by the court to be nothing more than a recognition of the principle of the public policy just previously mentioned. That provision of the statutes no longer remains a part of the statutory law of the state, but since its elimination, the Supreme Court in the case of Mulligan versus Mulligan has affirmed the doctrines announced in the case of Parrish versus Parrish. The Supreme Court, reversing the decision of the Circuit Court of the 3rd District found in CCNS 585. It is clear that the Supreme Court has steadily adhered to the general principle announced in Parrish versus Parrish. An examination of the record in the case at bar discloses facts which present an entirely different problem for solution. In the Parrish case, The action was directed to the annulling of a decree that had therefore been granted divorcing the parties to the action. In the case at bar, the evidence shows that by the action of the Common Pleas Court of Montgomery County, Pennsylvania, a court of general jurisdiction which had jurisdiction of the subject matter and of the parties, a decree had been rendered in favor of the plaintiff in that case and against the defendant. The defendant in that case, plaintiff in our common pleas, had filed an answer in which she denied the charges of adultery made against her by the complaint in that action. The exemplified record of the proceedings in the Pennsylvania case shows that upon the evidence adduced at the trial, the court found her guilty as charged and accordingly granted a divorce to the husband. The effect of this decree was to fix positively the legal status of the parties so far as their matrimonial relations are concerned. Okay, we do have a word list. We've got Anna Mandrake, capital A-N-N-A, Mandrake, capital M-A-N-D-R-A-K-E, William Mandrake, capital W-I-L-L-I-A-M, Mandrake, same last name. Court of Common Pleas, capital C on court, of is lowercase, common, capital C-O-M-M-O-N, pleas, capital P-L-E-A-S, Montgomery County, capital M-O-N-T-G-O-M-E-R-Y, County, capital C on county, Pennsylvania, capital P-E-N-N-S-Y-L-V-A-N-I-A, Parish, capital P-A-R-I-S-H, Mulligan, capital M-U-L-L-I-G-A-N. And looks like that is it for the common nouns, or the proper nouns. Okay, so that will conclude the 200 jury charge for the RPR simulator. Good luck.